Hello class, welcome to my class on legal forms for this summer 2020. First of all, I would like to point out that law is a communications profession. It's very important that you are a good communicator, not just in speaking but in writing. I noticed that some of our students are very good in verbal communication, but when they write, it's totally different from what I expect. And that should not be the case. You should be consistent, good in verbal communication as well as in written communication. The reason for that is you speak up for others. You are an advocate. You write on behalf of others. And it is your responsibility to communicate clearly because people's rights to life, liberty, property, and security depend on you. And it is for this reason that during the bar examination, some bar examiners place a big premium on your ability to communicate. Okay, so let's take a look at the communication process. First of all, here we have different parts of the process. We have sender, message, channel, receiver, and feedback. In this process, the most important is feedback, of course, because no matter what kind of communication we make, if we do not receive feedback or if we do not get the feedback that we expect, then our communication is a failure. So I have come up with certain scenarios here in order to concretely explain to you how important you must understand the communications process. Let's say you're communicating with your client. You are the sender. The message is the legal advice that your client is asking from you. Your medium is or channel is written legal opinion, and the receiver, of course, is your client. And your client's response is your feedback. In another scenario, let's say that you are representing your client and you're communicating with the debtor of your client, demanding payment of the debtor's obligation to your client. So the sender is yourself, message is your demand for payment on your client's behalf, your channel is your demand letter, the receiver is the debtor of your client, and feedback is your debtor pays your client or writes a reply. If your communication does not result in that feedback, then your communication is a failure. So also in another scenario, we have a court case. You are counsel for the plaintiff. So you are the sender. Your message is that your client is entitled to his claim in accordance with the complaint. The channel would be the court proceedings, the pleadings, motions, evidence, memorandum. The receiver of your communication is the judge, and your feedback is that the judge must decide the case in your client's favor. If you do not get that favorable feedback, you can say that your communication has failed. So this is how important it is for you to understand the communication process. There are 10 goals of communication. We have to inform, number one. But of course, in our profession, we seldom communicate just for the purpose of informing. Okay? It's more of number two, to request a specific action. Number three, to influence or to persuade, especially if we are negotiating or if we have a court case in which we are representing our client. Number four is to inspire. Five is to motivate. Six is to build goodwill, build relationships. This is, for example, when we are entering into amicable settlement or alternative dispute resolution. And then seven, we have to learn. Number eight is to be inspired through the exchange of ideas. Number nine is to promote a cause, which is another goal of an attorney. If you are an advocate, you are promoting a cause. And number 10 is to entertain. Every communication has a goal. So you have to be very, very, very clear about your goal in order to reach your goal. If you do not know what your goal is, then how can you reach that goal? The coverage of this course, when we say legal forms, we are dealing with non-judicial forms. There are 13 different forms that you're going to prepare in this case. The form will be dictated by the objective. Okay, so here I have some two examples: deed of sale of real property by installment and demand letter, to vacate preparatory to an ejectment case. So the objective, well, we'll tell you what kind of form it should be. In Practice Court 1, you will be studying judicial forms, and your goal here is to win the case. Now, so we will be expecting a certain outcome in all our communications. Therefore, we must communicate clearly. And we can do this by using plain English. Plain English is readable English. Readability is a measure of how easy it is to read written material. There are different kinds of readability formulas or formulae in which the number of words in a sentence, number of syllables in a word, paragraph length, among others, are considered. There are different types of tests, and scores are generated by these tests. So here you can see a table for Flesch-Kincaid reading ease scores, or using the Flesch readability formula. The higher the number, the easier it is to understand. So yung pinakataas, you can see the score of 90 to 100. That's a material that is readable, very easy to read for a 5th grader, an average 11-year-old student. In the middle, you see a score of 60 to 70. That's plain English, very easily understood by 13 to 15-year-old students. And at the bottom, that's a score of 10. That's very, very, very difficult to read. Extremely difficult. It says here that it is best understood by university graduates, but even then, it is extremely difficult and very technical. And for that, I have an example from the case of Javellana versus Executive Secretary, which you are familiar with. I would like to read only the first sentence. Okay? Even if conclusiveness is to be denied to the truth of the declaration by the President in Proclamation 1102, that the people through their citizens' assemblies had overwhelmingly approved a new constitution, due regard to a separate, coordinate, and co-equal branch of the government demands adherence to the presumption of correctness of the President's declaration. Question. Upon hearing that, or upon reading it for the first time, did you understand the sentence? No, because it's very, very difficult. You have to read it several times in order to understand what is it really saying. So if you look at the bottom, I subjected this to the Flesch readability formula, and the score is 37.2, classified as difficult to read. If we go back to the table, 37.2 is towards the third. It says college level, difficult to read. So yun na yung ibig sabihin ng 37. What more if the score is 10? Then it is virtually unreadable. Okay? And ayaw natin ng ganun. So, akala ko kasi, we hear that phrase, sabi nga nila, maraming namamatay sa akala. Okay? Make it easy for the reader so as not to waste time. Don't let the words get in the way of your message. But more than that, in my more than 30 years of practice as an attorney, I realize that a lot of legal disputes are caused by unclear communication from personal level to corporate level. Pwedeng magkapitbahay, hindi nagkaintindihan, mag-asawa, hindi nagkaintindihan, or something in the contract was not easily understood. Kahit personal or corporate, ang dami-dami sanang dispute na pwedeng ma-avoid if only the communication is clear. And that is our objective. Okay? We don't want there to be any dispute simply because of bad legal drafting. So don't leave any room for misunderstanding. Keep it simple. Keep it clear. Now, my main material for this is R. Wydick, Plain English for Lawyers, and I underlined an excerpt from his book. I'd like to read it. It says here, banks, manufacturers, and other businesses discovered that documents written in plain language can reduce costs and increase profits. For example, an automaker's clearly written warranty can help sell cars, and a lender's clearly written loan agreement can reduce costly defaults and foreclosures, which is true. Okay? If the ordinary person, ordinary businessman understands the documents that he is signing, then there will be minimal legal dispute. Okay? And it will save time and it will save money. So This writer, Mr. Wydick, again, quoted, I have here an excerpt from his material in which he's quoting a New York lawyer talking to his associates. He says, "Good legal writing does not sound as though it had been written by a lawyer." Okay, remember that. Okay, so here is an excerpt from the case of Palsgraf versus Long Island Railroad Company, written by Justice Cardozo. This is a very well-known excerpt because of the way it was written. Sentences are short, there are many action words, very easy to understand, and you can even paint a picture with the words that are used. And this is the way legal writing should be. It is not wasting the reader's time. It communicates the message very well. So I'd like to read it. Plaintiff was standing on the platform of defendant's railroad after buying a ticket to go to Rockaway Beach. A train stopped at the station, bound for another place. Two men ran forward to catch it. One of the men reached the platform of the car without mishap, though the train was already moving. The other man, carrying a package, jumped aboard the car but seemed unsteady as if about to fall. A guard on the car, who had held the door open, reached forward to help him in, and another guard on the platform pushed him from behind. In this act, the package was dislodged and fell upon the rails. It was a package of small size, about 15 inches long, and was covered by newspaper. In fact, it contained fireworks, but there was nothing in its appearance to give notice of its contents. The fireworks, when they fell, exploded. The shock of the explosion threw down some scales at the other end of the platform, many feet away. The scales struck the plaintiff, causing injuries for which she sues. So that's very, very good legal writing without any legalese as much as possible. So the rules. What rules are you going to observe in this class? These are just some rules. There are many others which you will discover as we go along. So number 1, omit surplus words. 2, use base verbs. 3, prefer the active voice. 4, use short sentences. 5, arrange words carefully. 6, choose words carefully. 7, avoid language quirks. Omit surplus words. In a sentence, there are two kinds of words. We have working words and glue words. Working words carry the meaning of the sentence. Glue words hold the working words together so that the sentence won't read like a telegram. So these are words like the, or so, that, or a. So I have this sentence in red. A trial was requested by the defendant. The working words are trial, requested, defendant. They are underlined, and there are 3. The glue words are a, was, by, the. That's 4. So in this sentence of 7 words, 3 are working words and 4 are glue words. That's too many glue words for a 7-word sentence. You have to reduce the glue words, and you can do that by moving defendant to the front and making it the subject. So the defendant requested a trial. The glue words were reduced from 4 to 2. The sentence is tighter, it is more direct, and you can create a picture in your mind. Now, another example. The ruling by the trial judge was prejudicial error for the reason that it cut off cross-examination with respect to issues that were vital. Okay, that has 24 words. Nakakapagod basahin. Okay, and the working words are 11. The glue words are 13. You can shorten this into the trial judge's ruling was prejudicial error because it cut off cross-examination on vital issues. So from 24 words, we reduced it to 15 words. Next, another sentence. In some instances, ay yung phrase na in some instances, you can shorten that with the word sometimes. Okay, so again, in some instances, insofar as participants are concerned, the instructions are not understandable because they are too poorly written. So, substitute some phrases. Yung some instances, gawin mong sometimes. And then you rewrite the sentence. And this is how it is rewritten. Sometimes, instructions are too poorly written for the participants to understand. See, it's much, much better. Next, avoid compound constructions. What are compound constructions? This involves the use of 3 or 4 words to do the work of 1 or 2. So better prefer the shorter number of words. Always, always. So yung with respect to, you use on. For the reason that, use because. At that point in time, use then. By means of, use by. By reason of, because of. By virtue of, use by or under. In as much as, say since. In connection with, say with, about, or concerning. In favor of, use for. So the decision was rendered by the judge in favor of the plaintiff. The decision was rendered by the judge for the plaintiff. Or better, the judge rendered the decision for the plaintiff. Okay. Next phrase, in order to. Just say to. In relation to, use about or concerning. In the event that, use if. Okay. In the event that the plaintiff loses, use if. If the plaintiff loses, it's better, it's sharper. Then in the nature of, say like. Prior to, use before. Subsequent to, use after. With a view to, just say to. With reference to, say about or concerning. And for the duration of, say during or while. Next rule, avoid word-wasting idioms. Yung phrase, the fact that, for example, it doesn't mean anything. Okay, so this sentence, the fact that the defendant was young may have influenced the judge. Alisin na lang yung phrase na yon, which doesn't mean anything. So say, the defendant's youth may have influenced the judge. So other examples, the fact that she had died, just say her death. Or he was aware of the fact that, say he knew that. Or despite the fact that, say although or even though. Or because of the fact that, just say because. In some instances, the parties can, just say sometimes the parties can. In many cases, you will find, just say often you will find. And that was a situation in which the court, and so on, just say there, the court. Okay. Disability claims are now more frequent than was formerly the case. Just say disability claims are more frequent now. Injunctive relief is required in the situation in which, just say, injunctive relief is required when. Next, in the majority of instances, the grantor will. Just say, usually. Okay, the grantor will. Say yung in the majority of instances, the same as usually. Then next, during the time that, just say during or while. For the period of, just say for. Insofar as blank is concerned, don't use this phrase. And then next, there is no doubt but that. Just say doubtless or no doubt. Next, the question as to whether. Just say whether or the question whether. Next, this is a topic that. Say, just say this topic. And until such time as, just say until. Okay. Next rule. Focus on the actor, the action, and the object. Who, the actor, is doing what? The action. To whom, which is the object. Start with the actor, followed by the action, then the object. So the sentence, it is possible for the court to modify the judgment. Who is the actor here? The court. What is the action? Modify. What is the object? Judgment. So just rearrange it so that you have that order. Actor, action, and object. The court can modify the judgment. From a sentence of 10 words, you reduce that to 6 and made it more powerful. Yung salitang it, sometimes it doesn't mean anything. Like, it is obvious that the summons was not properly served. You can take that away, yung it. Just say, obviously, the summons was not properly served. Yung there, sometimes it doesn't mean anything. So, there were no reasons offered by the court for denying punitive damages. You can just say, the court offered no reason for denying punitive damages. From a sentence of 12, you reduce this to 9 words, and it is even more powerful. Okay, so that's the end of video 1. You now have to do the first exercise. That is your assignment for today.